No, I don't.
The virus held up her security deposit.
I missed the walkthrough because I had COVID symptoms.
Your Honor, he didn't even let us know.
It's irrelevant to this case that you had COVID.
Now, a landlord holds nothing back.
You want me to go to a walkthrough and infect somebody with COVID?
Send your mother, send your father, send a friend. You're full of baloney.
This is Judge Judy. Michelle Spaulding is suing her former landlord, Kirk Wilterding, for the return of her security deposit.
Justice case number 113 on the calendar in the matter of Spaulding versus Wilterding. Parties have been sworn in.
Ms. Spaulding, your case is a relatively simple one. It is your claim that the defendant owes you your security deposit back. You and your family rented a house from him.
That is correct.
He gave you a 60-day notice. You did, in fact, move out, and he retained $3,950 of your security.
That is correct.
So far correct? Okay, so, Mr. Wilterding, I'm going to start with you, sir. The Spauldings rented your house. They gave you in security deposit $3,950,
Correct.
which you know you're supposed to keep segregated in a separate account. Do you know that?
I do know that, and it was
That's
segregated.
a yes? Good. And you can prove that to me if I needed it.
Sure.
Sure.
Yes. I have it in a separate account that's one of my LLCs, not a personal account.
What LLC do you have there?
Just my account.
$3,950.
My account. And I actually sent them a copy because they asked
just a
for
second.
it.
Then I'm just asking you, why can't you tell me what bank you have their $3,950 in?
It's Wells Fargo.
Okay, let's proceed a little further. According to you, you had a girlfriend, you were moving to California, you lived in your house for a couple of years, then you moved with your girlfriend, then COVID struck, and you decided you wanted to move home. They were already living in the house, you gave them a 60-day notice. That's what you wrote in your answer and swore to. Do you remember that?
Correct.
Good. And they did, in fact, move out. And you made a date to come with them as a result of your 60-day notice. You made a date to do a walkthrough with them before they left, which is what people do when they have a rental property so that the people are moving out, say, this is what the place looks like, and you have an opportunity to look at and say, this is my damage, and I'm going to deduct that from your security deposit. You don't have to put anything anywhere. You weren't feeling well on the day of the walkthrough. That's what you wrote, correct?
Correct.
And according to you, you lost your sense of
Walkthrough.
Well, it has to do with the walkthrough, sir, because you say by the time you entered the house and regained your sense of smell, that's what it has to do with it. You said,
I didn't say
that
any
in your
of that.
answer.
You're just making that up. I didn't say any of that.
Okay.
I missed.
Really?
If you would
Okay.
like me to explain,
Just a second.
I missed. If I can
No,
explain.
I'm just looking at it. I may, just a second. I may have been mistaken, so I'm going to read your answer. You said, due to COVID-19, I decided to move back into my house. I gave them a 60-day notice, and they complied. Michelle asked for her deposit back on the day they moved out. I told her she had to wait for damage checks, but you already had a date for a walkthrough that you didn't go to. I started feeling ill, so I missed their walkthrough. That's your sworn statement, sir. I have your signature on it.
It says nothing about smell.
Soon after that, I moved back into my house. I got COVID-19. Following my doctor's instructions, I quarantined until I felt better. It took a full month before I was symptom-free. That's what you wrote. When I finally got my sense of smell back, I knew I wasn't crazy. I can't make that up.
30 days later?
The smell of dog was obvious. The smell of dog was obvious, and I needed to change the carpet and pad. That's what you swore to in your answer, sir, right?
See, I have a letter from my doctor, so I did not want to infect them. I didn't say that I didn't have smell.
I don't care.
And that's what...
No, just a second. You said...
30 days later.
You just said, I don't care, sir. You owe them $3,950.
No, I don't.
You missed the walkthrough.
There's more to the story. I missed the walkthrough because I was sick. I had COVID. So you want me to go to a walkthrough and infect somebody with COVID?
Send somebody in your place.
Your Honor, he didn't even let us know.
Send your girlfriend. So just a second.
I didn't have anybody available. It's a 2-hour drive. I have nobody available.
Send your mother.
No one.
Send
my
your
mother.
father.
My mother
Send
lives
a
in
friend.
Minnesota.
Hey, listen to me, sir. You're full of baloney because you lived in that house according to you
if you
for
would like
2
to,
years.
I came a long way. If you'd like to actually hear the story and I have evidence, why don't you let me talk?
Listen to me. It's irrelevant to this case that you had COVID. It is totally
How is it
irrelevant
irrelevant
to this case.
Why do I wear a mask then? We're not supposed to infect people. We're supposed to quarantine. Really? So Judge Judy says nobody has to quarantine.
No. How many times have you had COVID?
No.
I've had it twice.
No, shh. No. Listen to me, sir. Listen to me. Don't talk over me. I wouldn't suggest.
Well, you're not letting me talk. Why am I here?
Personally,
you're not letting me talk. Why am I here? Why am I here?
You're here to pay $3,950.
No, I'm not.
This case has been concluded. Parties are excused.
I'm honestly just happy that the truth came out. He clearly showed his true colors.
Because my whole house smells like dog. My brand new house, 2,800 square feet of carpet, smells like dog.
And that was my total interaction with him the entire time that we were his tenants.
They had it cleaned, they put perfume on the carpet, and it stinks.
Everything that comes out of his mouth is a lie.
So I have 2,800 square feet of dog carpet. It's $6,500 to fix. So their measly deposit doesn't even cover it.
I'm glad I'm done with this nightmare and I don't have to deal with him anymore.
All parties in the matter of Roberts versus Patton. Step to the podium.
Charles Roberts is suing Bryn Patton for the return or value of a dirt bike.
Mr. Patton, I'm going to start with you, sir. Mr. Roberts had a non-running dirt bike, and you own a mechanic shop, and he asked you sometime last year if you could get the bike up and running.
Correct,
So far correct?
Correct.
So I want you to understand that Mr. Roberts, who I haven't spoken to yet, looks like a reasonably intelligent man. And you came out and you looked at the bike for the purposes of giving him an estimate as to how much it would cost to get this non-running dirt bike up and running. So far, am I correct?
Yes, sir.
Estimate of what you thought, because you're the professional, of what you thought it would take to get the bike up and running. Correct?
After we went through it, Your Honor, and diagnosed everything and did a complete workup on it.
No, at the house, before you took possession of the bike, he asked you for an estimate.
Which we cannot provide.
Did you give him?
No.
Well, what did you look at the bike at his house for?
Actually, we just went to pick it up to get it going for him.
Okay, great. So you went and picked it up. On what date did you pick it up? Do you recall, Mr. Patton?
I don't recall the exact date, no, ma'am.
Do you recall the month?
April or May of last
Mr. Roberts, just give me the month that he picked up the bike.
It's unclear, and it's not documented. I believe it was March or April.
Say it was March in your papers.
That's my best recollection, Your Honor.
March of 2020. Okay, so you picked up the bike, Mr. Patton, according to you, and you took it back to your shop for a diagnosis and an estimate of what it would cost to fix it. And you didn't keep that estimate to yourself because you're in business. So you relayed that estimate to Mr. Roberts. What did you tell him it would cost to fix the bike after you diagnosed it? No, I don't want to hear the about. Now you took the bike back to your shop.
We were given the instructions to complete.
I'm giving you a question, sir. And what I suggest you do is a believable answer. If you don't, I assume you have family who are among the 9 or 10 million people who watch this program every day. I said to you at the beginning, Mr. Roberts is an intelligent person. If I took my bike or my car into a mechanic to be repaired, and they said I have to do a diagnostic, and they took the car to do a diagnostic, then they communicate with me as to what it will cost to fix it after they've done the diagnostic. So don't give me a lot of who shot John.
Judge Judy continues in a moment.
Now, I'm not believing you.
Okay. Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity. Sir, don't look slick to me, sir. I can tell slick. Don't think of what I'm saying to you.
And later today.
I loaned her $1,000. The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
Tell me how that happened.
She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
Mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
What I'm asking you, sir, is after the diagnostic, what estimate did you give them?
We were given an order to fix the bike and get it running so that it was in proper running condition. He was leaving town.
I don't believe. Just a second.
Okay.
Now, I'm not believing you.
Okay.
Mr. Patton, I'm not believing you, sir.
Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity, sir. It belies credulity. That somebody had a non-working dirt bike and said, as you're quoted in your answer, whatever it costs to fix it, fix it. So now, since I don't believe you, I'm going to ask you a couple of other questions, because that's what this case is about. He wants his bike back, and you have a ridiculous counterclaim. Now, is the bike currently, don't look slick to me, sir, I can tell slick. Don't think of what I'm saying to you. Is the bike currently running?
Yes, ma'am.
And is it currently in your shop?
Yes, ma'am.
Okay. Now, are you getting an appearance fee for coming to this program today?
Yes, ma'am.
How much?
To be honest, I do not recall. Each time things have been very different. So with the COVID, things have...
Fine. So you don't know. Whatever it is, you know it's something,
That's right.
Okay, good. So nothing better happened to this bike, because they're going to hold whatever that appearance fee is until we make this exchange and we have a running dirt bike. Do you understand?
Absolutely.
Great. Now, originally you say he came out and looked and said maybe between $300 and $400. Okay, that's a good guesstimate. You know, that never is what it is. You never get charged exactly the top end of an estimate.
Right.
What you say to me is, in your complaint, is that in July, so we had March, April, May, June, now in July, Brian texted me, which you have, that the cost of the repairs had increased and would be $580. Do you recall texting him that figure, sir?
I texted many times. Oh, wait.
No.
I apologize.
Do you recall texting him that the bill, which originally you said would be maybe between $300 and $400, is now $580 in August? Do you recall saying that to him?
Yes.
Okay. We'll take a look at that text.
Here's the text. August 21st, he says, $580 plus tax.
Plus tax on parts.
Fair enough.
Right? Say repairs was $600, but he said, I think I have a buyer. Forget any other deal. $600 with the repairs then. And according to Mr. Patton's answer, Mr. Patton, I want you to listen carefully. You said I had the bike fixed within a few weeks. So that $580 plus tax on parts was a completed figure. That's what the figure was, $600, which was twice the lowest estimate that I believe that you gave him, but a couple of $100 more than the highest estimate. And according to you, you said to him, I kept asking Charles to pick up his property and pay his bill. He kept making excuses. When I told him it would cost $1,500, he complained. Why would it cost $1,500?
Judge Judy continues in a moment. And later today,
we were arguing, and I was being told that I'm not thankful for anything that he does.
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
Judge Judy. Charles Roberts says mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
Now, why would it cost $1,500?
I don't recall why I don't know how that conversation even occurred. I don't recall it.
You don't recall telling him that the cost was $1,500 now?
Charging him $1,500? I do not recall that. No, ma'am.
Did the person who wanted to buy the bike, because I'm looking at that text message, Mr. Patton, did the person who wanted to buy the bike, was that your son?
He's my son, yes.
Okay, and then he decided not to buy it?
Correct.
Did he use it?
No.
Did he ever ride it?
Yes.
How many times? Once or more than once?
During the
once or more than...
More than once.
More than 10 times?
No. And it's just not my
Between
son.
5 and 10
we have technicians that ride it. As we repair things, they have to be test-ridden.
No, I'm talking just about your son, sir, not about the technicians, just your son.
Oh, no, he only rode it one time. The first time that he was going to ride it. He wanted to see if he was going to buy it or not.
Okay, very good. All right, it's a relatively easy case, Mr. Roberts. You see, you didn't have to say anything. You have dollars and go and retrieve your bike. You can do that with a marshal. The bike will be in perfect running order because that's what Mr. Patton says. It's in perfect running order. And there are things that we will hold hostage in order to make sure that you get that bike in good running order for the cost of $600, which you think is fair, correct?
Thank you, Your Honor.
Very good. Very good. We're finished. That's it.
Thank you.
Thank you.
This case is concluded. Parties are excused.
Well, I think it's a fair decision. It's a little frustrating because he quoted me $300 to $400 to repair the bike.
I believe it was a fair decision. I believe we kind of came here and got the answer we wanted.
Then the bill came back as $580, and then when I went to pick it up, he presented me with an invoice for over $1,000.
There was a dispute between the payment that he felt was owed and what we were charging.
I'm just like, this is a hostage situation. I'm not going to play that game.
All parties in the matter of Swenson versus Miller. Step to the podium, please.
Doug Swenson is suing his ex-girlfriend, Kathy Miller, for an unpaid loan.
Mr. Swenson?
Yes, ma'am.
According to your complaint, sir, the defendant was your girlfriend for a couple of years.
Yes, ma'am.
From when to when?
It was March of 2017, I believe, up until September of 2020.
And it is your claim that just before the breakup, you loaned her $1,000.
Yes, ma'am.
You had...
September 16th is when I was.
The answer says on October 18th, he showed up at my house unannounced about the money.
We could have the months.
But you broke up?
Yeah, it was in September.
In September, you broke up?
Yes, ma'am, on the 16th.
Okay. Did you go to her house to collect the money in
Yes,
October?
Ma'am. Yes, I did.
Okay. And you went to retrieve, according to you, the money she owed you?
Yes, ma'am. $500.
Hmm?
Yes, ma'am, the $500 that she owed me. That's why I went there.
Well, when did she give you any money towards the loan?
Okay.
I thought she gave you that money
okay,
when you broke up.
Judge Judy continues in a moment. Closed captioning sponsored by Real Cases, Real People. Judge Judy. Have you been cheated? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Now, you went to retrieve, according to you, the money she owed you.
Yes, ma'am. The $500 that she owed me. That's why I went there.
Well, when did she give you any money towards the loan?
Okay.
I thought she gave you that money
okay,
when you broke up.
I loaned her $1,000. The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
She gave it to you? Look, listen to me.
She said exactly to me,
Tell me how that happened.
Yeah. Okay, well, now here's what happened. She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
We were arguing, and I was being told that I'm not thankful for anything that he does because he came and helped me find the car. He knows about cars. So that night...
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
I did.
Did you do that?
Because he was putting it in my face.
Well, that's not what you said here in your answer, which is the only reason I'm hearing this case, because you said he blocked my car in so I couldn't leave. I had no choice but to give him the money. But that's not what you just told me.
That was the next day.
What do you mean that was the next day?
The next morning he came to my house.
I want to know when it was that you gave him the $500.
When he came to my house.
Not at his house.
No.
I don't believe either one of you. Actually, it doesn't make any difference. If you gave him the money, then you owe him the balance of $500, okay? And by giving him the $500, you acknowledge that you owed him $1,000, you gave him $500, you owe him $500. Oh, my God. Thank you very much.
Thank you.
This case is concluded. Parties are excused.
On the next Judge Judy.
I think it was absolutely correct.
I guess it's fair.
I helped her out, and I felt she was very unappreciative.
Well, he gave me the money, and he said, don't worry about it.
We got in a huge fight. She wanted to leave my house in the middle of the night and stuff, and...
You know, don't take anything from anybody.
Yeah, I just, I wanted my money back.
Just do it on your own.
A wife finally had enough.
Does your husband have a lawyer in the divorce?
He don't even know I'm filing for the divorce. I haven't spoken with him since I left.
But her mother-in-law...
You were living with your son and his wife?
Yes.
...stands behind her son.
Your Honor, she's not filing for a divorce. She haven't filed for the divorce, and she's not.
I will, as soon as I get home. I left the house due to domestic violence.
This is Judge Judy. Calvina Zeno is suing her estranged mother-in-law, Regina Marzette, for the value of a Samsung tablet and unauthorized charges made on a joint bank account.
Judge's case number 99 on the calendar in the matter of Zeno versus Marzette. Parties have been sworn in.
Miss Zeno, you are still currently married to the defendant's son. You and the defendant's son separate.
About 2 years ago.
Did you move out or did he move out?
I left the house due to domestic violence.
It's your claim that you left behind a tablet, a Samsung tablet, and that the defendant at one point said she didn't have it, but then she did, in fact, have it and used it once, according to you. Where is the tablet now?
She has it.
Did you find her tablet?
I had seen it. She had left the tablet there. I never used it or have it. And she came back to the house 3 or 4 times.
Where is it?
I believe it got stolen. My son had left it outside on the gate to go in the apartment, and he came back, the bag was gone.
Was he living with you?
I was living with them.
Okay. She doesn't have your tablet.
I never used it.
From 2 years ago. Now, you have a counterclaim. Your counterclaim is money owed for credit card charges.
Yes.
I assume these credit card charges were made prior to 2018, were made when you were living with your son and his wife?
Yes. We had it was around 2016. I let her start using it, put on the authorized user, and we had agreement. As long as she paid it, I didn't care what she used it for or whatever. As long as she made monthly payments on it. In May of this year, she stopped making payment. Then she made 2 more payments though. She stopped Wells Fargo, and I accidentally used it charged my DMV $35, and so she closed the account, and I didn't know until I tried to use it, and then I texted her saying the account is closed. She said, yeah, I closed it because you made $35 charge on it and went over her account.
We're not getting involved in this.
Okay, that's when she stopped, and then she
fiasco that happened in 2018.
But she was making payments up to this year, and then I'm telling you the reason why she stopped it first. Because I used the card that she was making the payment up for with the credit card payment with, and the account went over, and she closed the account. And then,
do you have a lawyer in your divorce?
No.
Does your husband have a lawyer in the divorce?
No, I'm the one that's filing for the divorce. I have to turn in my paperwork. He don't even know I'm filing for the divorce.
Okay.
I haven't spoken with him since I left.
Okay. Does your husband work?
I'm not sure. I don't communicate with him anymore.
Your mother-in-law says that you had an individual agreement with her to use a credit card prior to 2018. What was that credit card used for?
The card was used for her son charges. I also made charges on the card. I used it for my guard card, which I believe is paid off. Like she said, I've been paying it since the card been on there, but our card got towed a few times. Security guard card, license. I want to say about $800.
And you've been making payments since 2018 of how much a month on the card?
$150.
Do you have the credit card receipts or the bills that show how much she was making payments on? I'd like to take a look at them.
I'd like to show you this. This one I stop her from using it, showing the balance. When I stop her from authorized user because when it went over $5,000.
Who else is an authorized user on that card?
No one else. I didn't even use it, Your Honor. I make no charges on it.
Prior to 2018?
I have never used that card myself.
Not you.
No one else, Your Honor, used the card. Not even me.
Do you have a card?
I have other cards. That's why I only set that aside for her to use, for I wouldn't have no disagreement with the charges.
Tell me what you used the card for before 2018.
All I can remember is using it for is my guard card and to get the cars towed out because he kept getting our cars towed. So we had these, she said, for emergencies, and we used it to get it towed out, but I continued to make the payments. That's why I don't understand why she's saying that it went over $5,000. Last time I seen it was at $4,800, and that was years ago.
Your Honor,
I don't understand. I never seen the statement, so I have no clue what's on there. I don't know who used the card.
I have statements you use.
Just a second. On September 17th, did you pay a Progressive insurance bill?
No. All my car insurance bills was paid on my bank account.
I don't have Progressive, Your Honor. This is all her charges and the wireless
What year did you
phone.
say was it, ma'am?
September 17th.
2008. This 2000.
Did you pay?
In 2018?
Yes, it was 2008.
No, in 2020.
No, this is 2018 right here. This when she was still...
Listen to me. This is a marital debt. These bills were accrued prior to the time that your son and
But our agreement was, I had agreement with her. As long as she pay on it, it's like...
What I'm telling you, it is a marital debt. Some judge, when she files for divorce, is going to determine whether this credit card...
Your Honor, she's not filing for a divorce. She
haven't
filed for the divorce, and she's not.
I have the paperwork at home.
She's not.
Well, I think that you should do that.
I will.
Because...
As soon as I get home.
Because I'm dismissing her counterclaim without prejudice. You have to file for a divorce so a judge can determine how much of this bill is a marital debt and whether your husband, her son, is responsible for any part of that bill. Like if a car was towed and it was his responsibility, but it was paid for on this card. I don't know, and I have, because when you file for divorce, one of the things that a judge will do is look at the equities of the parties and what they have and say this car payment, this bank account, this credit card bill, this is either marital property or individual property. And if those charges were made prior to 2018, some judge in a matrimonial part is going to determine that they're marital property, marital debt, which means that your son may be responsible for some, all, or none of that debt. Do you understand? Okay.
Yes, but...
Well, I understand. And I'm the only one who has to understand. Goodbye, good luck, have a happy life.
This case is concluded. Parties are excused.
To build up her credit.
She wanted to help me build my credit.
She didn't have credit at the time.
I wasn't the only one to make the charges on the card.
I still love her, but she went on with her life, so I let her be.
It's time to file them divorce papers.
All parties in the matter of Lyons versus Munoz. Step to the podium, please.
Phillips Lyons Jr. is suing his former landlord, Inez Munoz, and her daughter, Roxana Munoz, for wrongful eviction, the return of his security deposit, and damaged property.
Mr. Lyons, you were a tenant of the defendants for 3 years.
Yes.
And you had a security deposit of $1,400. Seeks the return of the entire security deposit. She already sent you $500. She retained $900 of the security deposit.
Yes.
In addition, you're asking for other money for a whole lot of nonsense. Damaged property as a result of a pipe burst in February of 2020. You didn't move out until July. I assume the damaged property that you're referring to is the damaged property as a result of the pipe bursting.
No.
What damaged property as a result of what?
The roof leaking. There was heavy rainfall at the end of 2019, beginning of this year, that ruined our furniture, causing mold in the house. There was water throughout the house, damaging the furnace.
Okay, I get Mr. Lyons, understand this, sir. You're a renter. If there's a leak or a burst pipe and your stuff is damaged, that's what renter's insurance is for. That's what homeowner's insurance is for. Yeah. That's not what this nonsense is. That's why I'm saying there's a whole bunch of stuff here that's nonsense. You want the return of your security deposit. You also put in a claim here for wrongful eviction. But I read your complaint, and I read in your complaint that you gave her a 30-day notice on July 21st.
Yes.
You gave her notice. She didn't evict you. You gave her notice that you were moving out.
Witness.
Good. And had you been planning on making that move? Is that why you gave her a notice on July 21st?
Yes.
That you were moving in with a new roommate? Yes, so she didn't evict you.
Judge Judy continues in a moment.
Is that all your junk out there? Sir.
The property damage,
Is
yes.
that all your junk out there?
Yes.
That's not property damage stuff. That's stuff you didn't want. There's a broom there. That's ridiculous.
Phillips Lyons Jr. is suing his former landlord, Inez Munoz, and her daughter, Roxana Munoz, for wrongful eviction, the return of his security deposit, and damaged property.
Okay. Now let's talk about the return of the security deposit. Then the burden's on her. You had $1,400 of his security deposit. You returned $500. It's your responsibility to show me photographs of why you retained $900 of his security deposit.
Okay, $200 for the trash that was left in the curb. I have pictures.
Oh, so you have pictures and a bill or a receipt?
Yes.
For who you paid to get rid of it?
Yes.
Good. I'd like to see the photographs and the bill. It's not $200 worth of trash.
Oh, there. Yes.
Is that all your junk out there, sir?
The property damage,
Is
yes.
that all your junk out there?
Yes.
That's not property damage stuff. That's stuff you didn't want. There's a broom there. That's ridiculous. Okay, so $200. Can I see the bill for removing all that trash?
There's going to be 2 bills, okay, for the cleaning.
Yes, I'd like to see them both. That says cleanup.
Yeah, it's $200 for the cleaning the curb and $200 to clean the apartment.
Okay, so $200 for cleaning the curb.
Yes.
Now, I didn't see pictures of inside the apartment. What are you alleging was wrong inside the apartment? So you do understand you owe her. She rightfully withheld $200 so far for cleaning up the trash that you left outside.
I don't agree
I'm
to
telling
that.
you do. Okay. I don't care whether you agree to it or not. That's your trash to get rid of, not somebody else's. What is that?
Okay, these are the boxes, the refrigerator boxes where you keep your vegetables. That's one of them. Fungus.
Okay, what else?
This is the kitchen counter.
Well, I don't know what is on there.
What
are you showing me?
They're stains. The stains, I don't know if you can see, it's a yellow.
What else?
This is the drawer in the bathroom.
What color is it? Is it white?
The shelf is black, but this is a white stuff.
Stains. There's stains on the black.
What else? Did you take pictures, Mr. Lyons, of when you left the house?
Yes.
Did you take photographs? May I see them, please? Don't show me anymore. What is that?
Those are the pictures of the mold and whatnot growing in the bedroom.
No, I just want,
like that.
I want to see, sir. Is this how you left the apartment? I just want to see if you left it clean. Is what I'm not looking at your mold. I'm finished with your mold. Get homeowner's insurance.
Okay.
Looks like he left the inside pretty clean.
And that's one.
Go ahead. Keep going. Is that when you left, sir?
Yes.
Go ahead. What are you showing me?
Of the kitchen cabinets. That's just one of the kitchen cabinets.
If they were cleaned out?
Mm-hmm. They were clean. There wasn't anything in them. That's the bathroom.
Okay. Got it. All right, Mr. Lyons, I don't have to see anymore. Okay. When Mr. Lyons left, he left in... Did you leave in August, sir?
August 1st.
You left August 1st. When did you re-rent the apartment?
September 3rd. September 3rd. No, not to clean.
You have to clean. He was living there for... No. No. Sorry.
Judge Judy continues in a moment.
Listen to me, sir. She didn't wrongfully evict you. You gave her notice. You had a kerfuffle about the date because you were sleeping. You don't get up until 2 o'clock. Then she called you. She wanted her rent. I'm not interested.
And later today.
You say I abandoned them. I was just miserable with humiliation, so I left them there.
Well, who would want those things back after she had been with some other guy and
I don't know. Maybe I wouldn't, but maybe Bert would.
Real cases, real people. Judge Judy. Phillips Lyons Jr. is suing his former landlord, Inez Munoz, and her daughter, Roxana Munoz, for wrongful eviction, the return of his security deposit, and damaged property.
Okay. He left August 1st. You paid $200 to take away his trash, which you shouldn't have left there. That's really your job, to hire somebody to take away all your garbage.
I did. She had told me that when she took those pictures and stuff of the place and the trash, she's like, these needs to be cleaned up. And she's like, you need to come back after she had wrongfully evicted us. And I had told her, I was like...
She didn't wrongfully evict you.
Well, the agreement was for us to be out on the 21st and on the...
Wrongfully evict you. You gave her notice. You had a kerfuffle about the date because you were sleeping. You don't get up until 2 o'clock, according to you, to go to work. And she called you. She wanted her rent. I'm not interested.
I have a proof.
I just asked you about the trash that you left behind. I'm just asking you, are you telling me that you paid to have it taken away?
Yes, I had it arranged. I had the city to come on that same week to come get it. And Roxanne knows about this because I had told her, said, okay. And then she's like, no, I'm not waiting that long. And then she got it taken care of herself.
Yeah,
and I had let her know via text.
I don't blame her. I don't blame her. So far, you're entitled to your $700 back of the $900. She paid $200 to have somebody clean up that junk that you left outside. The apartment looked pretty clean to me. And if you were lucky enough to have the apartment vacant only for 1 month, and Mr. Lyons was living there for 3 years, you have to paint the place anyway. You have to get it into shape. You can't rent it again right away. You know that. Right. Ridiculous. Okay, judgment for the plaintiff in the amount of $700. We're finished.
Your Honor?
Thank you.
Your Honor?
We are finito.
This case is concluded. Parties are excused.
Got sick because of the mold.
The way it was delivered to them and the way it was delivered back.
We told her about it, and she told us to clean it ourselves.
Not to be nice anymore.
Not to be so nice.
All parties in the matter of Lauder versus Draper, step forward.
Amy Lauder is suing her ex-boyfriend, Chris Draper, for an unpaid loan to get his truck fixed.
Miss Lauder, you claim that the defendant owes you for the balance of a loan to repair his truck.
Yes, Your Honor.
Tell me about that.
Back in July, at the end of July, his truck broke down and he needed to...
That would be July of 2012.
Yes. He needed money to repair it and he didn't have money. So he asked me to loan him $900 so he could fix his truck. And he promised...
And why would he ask you to make a loan to him?
He knew that I'd gotten money. My mom passed away back in 2011 and she left me some money. And so he asked me if he could borrow that money.
Were you dating at the time?
At the time I loaned him the money, we were not dating.
When had you stopped dating?
We'd broken up at the beginning of July of 2012.
On what date did you ask her for this money?
I'd never asked her for the
Are
money.
your hands in your pockets?
Yeah. She offered me the money.
No. You can't offer somebody money unless they know that you need money. Listen to me, I want you to follow. If I called Bird and we're talking and I say, you know, I have this truck that needs repair and I don't have any money, and Bird says to me, oh, I can help you out with that. That's understandable. But somehow it has to be communicated to Bird that...
Judge Judy continues in a moment. Closed captioning sponsored by... Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Now, did you receive a call from the truck company?
No, ma'am.
So you received a call from the truck company at your house?
No, I was at her house when it was on my cell phone.
Okay. So you were at her house when you got a call and you say, bring, hello, right? Got it?
I said, oh no, what am I going to do? I need some money. She's like, I'll give you money.
Oh, great.
Because I got money from...
How much does he owe you? That sounds so ridiculous.
I borrowed him $900.
No, you didn't borrow him
Loaned
anything.
him $900, and he paid me back $100.
Okay, good. Now we have a counterclaim, so that takes care of the $800 that you owe her. Now you have a counterclaim, and you said, I purchased a washing machine, a couch, a recliner, a TV, and a desk, and I didn't take these items with me because I just left the house. So
we had broken up.
Just a second. You said you left, and you said, I didn't take these items with me because I just left the house we shared after humiliation I endured when I found out that she had been cheating on me for almost a year.
Left at her house.
You say, I abandoned them. That's what you're saying in here. I left them there because I was just miserable with humiliation, so I left them there a year ago.
Well, who would want those things back after she had been with some other guy? And
I don't know. Maybe I wouldn't, but maybe Bird would. Judgment for the plaintiff in the amount of $800. Your counterclaim's dismissed. Goodbye.
You may step out.
Judge Judy continues in a moment. And on the next Judge Judy, made to move in the middle of the virus.
I didn't evict anyone. I put a pay or vacate, which is different from eviction.
I don't think that you can do that.
Next Judge Judy.
That's fine. I'm good with what she said.
I think it was fair, and I'm happy it's over with.
We both work at the IRS, and, you know, we got to be professional, and so this isn't professional at all.
I don't talk to him, I don't see him, so it's not too big of a deal.
I hope that we can just move on.
Don't loan money to anybody.
She needed more eyeballs on her website.
She wanted to know how much it would cost to retain my services.
You gave her a $5,000 deposit. I want to see your marketing campaign.
Do you want to see the logo that we created?
That would be a start.
You know what, Your Honor, I did not bring a copy of the logo.
Ridiculous.
This is Judge Judy. Amy Davis is suing Corey Dyer for the return of a deposit for marketing services for her beauty pageant coaching program.
Judge, this is case number 9 on the calendar in the matter of Davis versus Dyer. Parties have been sworn in. Sir, you may have a seat, please.
Miss Davis, you developed a website. It sounds to me as if it was sort of a mentoring website for young women who were preparing for beauty pageants, who needed some coaching. And as a former beauty pageant winner, and I understand from your complaint that you were,
yes,
you felt as if you had some qualifications to do that. The website was developed and you needed someone to help you market it, according to what I read, and you retained the defendant in order to do that. You gave her a $5,000 deposit. According to you, she did little or nothing to earn that. You want your money back. That's what the case is about. So how did you find the defendant?
The defendant found me on social media through Facebook.
Miss Dyer, tell me how you found the plaintiff.
I met at a birthday party for a mutual friend, and that's how I originally met Amy. I had a client who had recently launched from his stem cell business into a medical spa. We were doing a marketing campaign where we were looking for models to actually demonstrate the services. And I reached out to her and I explained to her what we were doing. And if she was interested, that she would receive over $5,000 in Botox, fillers, and lip injections.
If she was interested in modeling for this other client of yours?
Yes.
Well, how did it come about that you offered your services as a marketer to her?
That is how the doctor wanted to do it, in exchange for them coming. We had a group of where we were marketing to the masses to come in and see these services done. And so they would come in.
No, listen to me. You were offering her,
yes,
is what you're telling me, a job.
Yeah, it was.
I want to know how it came about. No. I want to know how it came about that she gave you $5,000.
Okay. So when we were finished, I was in the conference room and Amy came in and we started to talk. I wanted to find out how it went for her.
So you employed her? Your company employed her?
Yes.
Okay. And you were talking to her?
Yes.
In the conference room. That was in 2018?
Yes. It's September 27th.
No, I don't need a picture.
Okay.
Just tell me the story.
So I was in the conference room. I asked her how it went. She said she really enjoyed it. We started to speak. She asked me what I did doing for the particular company. I explained to her what I did in marketing, and she said that she had been wanting to take her coaching program online and was needing some help. And I told her that I would love to help her. I would love to learn more. She started to show me on her phone other people that she knew.
You mean this was all in the conference room?
Yes.
Shh. This was all in the conference room. Okay, that was after the gig. So you spoke for a while in the conference room.
Yes.
And she showed you what she was doing online, what the program was that she was doing online.
Yes, you are correct.
Okay, so
yeah, we
that
spoke for a couple hours.
Nice. Okay, that's good. And what happened next?
So she wanted to know how much it would cost to retain my services. I told her for what she's looking at to do something online, it would start her probably about $10,000 to start. And she says, I don't have that much. And I said, well, I mean, it sounds like a great opportunity. I'd like to learn more, but maybe we could do some rev share. Maybe what we could have you do is pay half of that and we rev share on the profits. And she said, that sounds very interesting. And so we talked a little bit more. And as I learned more about it, I got more excited because she was showing me these other accounts.
Are you talking to me about the conversation or were we talking about a different day? That's all
the same day, Your Honor.
September 27th.
Yes.
The same day. Okay. When was the next date you saw her?
She wrote me a check out that day.
No. When was the next day you saw her?
That would have been October 1st.
Where did you see her?
She came over to our office. She brought Greg with her.
Who was Greg?
The gentleman that is with her.
Your partner, your husband?
That's me, Your Honor. I'm a friend
He's
of
a friend.
Amy's. I'm also an
down.
attorney, but I'm not Amy's attorney.
Okay, just sit. You're a friend. Okay, so she brought Greg with her, and?
She told me and Jarrell and Emily that this was her boyfriend, and she wanted him to hear and learn more.
I don't care.
Okay, that's not important.
Doesn't matter. 27th, you didn't have a meeting. You were talking.
Yes.
She came to your office on October 1st.
Yes.
She had already written a check to you for $5,000.
She had.
That she gave you on September 27th. for which you did no work. That was just a sort of beginning process.
We actually started...
Right? You hadn't done any work.
Yeah, we actually had started all the research because we were there to meet with her on the 1st to go and show her all the research we had done. And so we spent about 300...
I don't know. I want to know what you did for her between September 20...
What we did is we spent that time preparing to see her, and we had done about 360 hours of research in researching...
Ridiculous.
What she needed.
Ridiculous. Ridiculous.
So the research is necessary.
What I'm telling you is between September 27th, which goes into September 28th, because you already had done a job on the 27th, you are not going to convince me that you did 360 hours between the 28th of September and the 1st of October. 360 hours, because there aren't 360 hours in that period of time.
We did, well, man hours. So there was 3 of us that did it, and then man hours, that's what it took, so that when we met with Amy, we could actually see what we were looking at.
Who's 3?
Myself,
Who's 3?
Jarrell, and Emily.
Who are those 2 people?
Jarrell and Emily are my partners.
Are they your children?
They are.
Okay, so you met with her and your 2 kids.
Yes.
How old are you?
I'm 55.
And how old are your children?
31. And he is an artist and a designer, and my daughter...
Just one second. I'm not finished.
Okay.
He's 31.
Yes.
And he was at this meeting on October 1st.
Yes.
Was he at that meeting on October
27, and she went to FIT and graduated in FITM and design.
And was she at the meeting on October 1st? Hello, Miss Davis?
Yes, she was at the meeting on October 1st.
So you were there, your 2 children, the plaintiff, and her friend.
Yes.
And what time was the meeting called?
What time was it called for?
What time was the meeting called for?
I'm going to say it was in the morning. Amy was running a little bit late.
In the a.m.?
Yes.
And I want you to show me what you presented to her on October 1st as a result of the 360 man hours that you spent on the 28th, the 29th, and the 30th. Show me what you presented to her. Okay, warranty of services.
Yeah.
What is that?
So this is basically showing her exactly line by line what we would be doing to be able to...
So this is what you say you're going to do for her. I want you to show me the product of 360 man hours of work.
We didn't know what we were going to be able to do until we researched and looked at all the other online pageant, the people and what they were doing, what they were charging, what their volume was, how many awards they had won. We need to have something to compare by to be able to create that marketing for her. And so that was the time.
You didn't show her anything, nor can you show me anything that you
Well, yeah, where the product started.
360 man hours.
Yes, so where that hit.
So show me.
So where that started.
You're a marketer.
You bet. So where that started was after our meeting with Greg and Amy. That's when we began and started to do the work. Amy had come in. She brought... Yes.
So now what you're saying is you didn't do any work between the 27th and the 1st except to prepare this one-page thing of what you proposed to do for her.
That would be correct.
Is that right?
Yes, that is correct.
Okay, good. So now that's clear, because I was confused about the 360 hours from 2 days. That math doesn't work for me, and I'm pretty dumb in math. So after they left and you had her $5,000, that was on October 1st.
Is when they came.
When was the next time you saw Miss Davis?
So the next time I saw her from the time that we were in the...
October 1st.
It was October 1st.
Very easy.
And this is important, Judge, because this is...
Pay careful attention to me.
Yes.
My question is a direct one. We are now in August of 2020.
Yes.
I want to know, after October's the next time you saw Miss Davis.
So the communication was there through
text
messaging.
That's not a so. That's not a so. No, that's not a so. That's a date.
Okay.
That's not a so.
October 2nd.
That's not a story.
October 2nd, 2018.
Where did you see her?
So she was texting us.
Where did you see her?
Well, she ghosted us after the 5th. I never saw her again after the 5th. Literally for a year, she ghosted us.
Oh, just a second. Listen to me. I asked you a simple question.
Yes.
From October 1st, 2018, until the next date that you saw her.
Well, it was by phone.
And you said October 2nd.
By phone.
No, not by phone. In person. She gave you $5,000.
Never saw her.
I want to know when the next time.
Never saw her in person after October 1st. She completely ghosted us after
$5,000? That's very...
She ghosted us for a year after the 5th.
I have no idea what you...
So ghosted is when they just don't show up. They don't show up to the meetings. They tell you they're late. They tell you that they have prepared their script like she did and she never prepared it. They lied and said she had all this information ready for us and we were all ready to start shooting her and filming her and she didn't show up.
So what I want you to do is show me what you did for her between October 1st, 2018 and today.
Judge Judy continues in a moment. And later today.
How much did Mr. pay you for the contents of the salon, other than forgiving you your rent?
It was the next 2 years' worth of lease.
I think I have a feeling that Bill got snookered. He got snookered by COVID, and he got snookered by you.
Amy Davis says she paid Corey Dyer $5,000 to market her beauty pageant coaching program. Amy claims Corey barely did anything.
What I want you to do is show me what you did for her between October 1st, 2018 and today. What you did for her, what your marketing company did for her, how it prepared. Just show me. Put up one at a time.
Okay, so here's the first one. We were prepped and ready to have her come in and to start filming her. She said that she got...
I'm not interested in text messages. I want to see your marketing campaign.
So you want to see the logo that we created? You want to see the logo that we created for her? Is that specific?
That would be a start. That would be a start. Take off the texts and show me a logo that you prepared for her.
You know what, Your Honor? I did not conversations.
Okay. Judgment for the plaintiff in the amount of $5,000 for her refund. We're done here. Thank you very much.
Thank you so much.
This case is concluded. Parties are excused.
Oh my gosh.
You can't doubt Judge Judy. I mean, as a judge, I agree that she knows what she's doing. She's been doing this for a long time.
This has been a long time coming. I'm so grateful. I feel like...
I didn't come prepared. That was on my end. I didn't come prepared with the logos and the things that we did with Amy.
Justice was finally served. Judge Judy was able to catch...
And so that's my bad. I truly wish Amy the very best, though.
Corey Dyer and many lies.
No, she was never pleased with anything. That was the problem.
But it just definitely wasn't the match for me.
All parties in the matter of Mushka versus Hallman approach the podium.
Michelle Mushka is suing Dennis and Brenda Hallman for the return of a deposit on a beauty salon and the return of stolen property.
Well, let me start with you, Miss Hallman. How long did you and your husband own this beauty salon?
5, almost 6 years.
And do you rent the space from someone?
I do. I rent the building.
From whom?
Bill is the owner of the building.
How much rent do you pay, or did you pay?
The first year, it started out at $1,500.
And what was it in 2019?
$1,750.
Were you current in your rent at the time that you sold these?
And I was 4 months behind on rent.
So far, you had a broken lease, and according to what I read in the complaint, you had not maintained your filing status with the state, correct?
I had a business.
That's either a yes or a no?
Yes.
So the asset that you were selling was what?
Was all the assets that were inside the salon.
What is that?
The mirrors, the chairs, the stations, the furniture, the decorations.
The renters, the people that rented.
I didn't ask you anything.
I was helping her out.
I didn't ask you anything.
Thank you.
Don't help her unless I ask you a question. Do you understand?
Yes, sir.
Perfect.
And the landlord, and I was selling the agreement from the landlord to the purchaser.
Did Bill tell you he was going to evict you if you didn't pay rent?
No, not at all.
Well, what's the reason for your not paying rent for 4 months?
Judge Judy continues in a moment.
Why didn't you give her money back?
She didn't ask for it back. She also stated that, I doubt you have it. She said, so I want everything that you have to do with this business. Sure. She wouldn't take her money back.
What are you, crazy?
Real cases, real people. Judge Judy. Michelle Mushka says Dennis sale of a beauty salon.
What's the reason for your not paying rent for 4 months?
I had a business partner, and she decided to fall in love with a military man, and she left the state. And so I was left to take over and pay everything on my own when she used to pay for half of everything. So I talked to the landlord.
Well, did you pay half your rent?
Yes, I did pay partial payments to Bill, and we made agreements that...
How much is partial payment? Let's go. I just want to know.
You know, there was 800, there was 400, there was 200. It just depended on the week and how much I was making at the moment. And my landlord was extremely
This is what
helpful.
the case is about. You agreed to sell the assets of a place that you were behind in rent on that was not a legitimate salon because the license hadn't been maintained for a couple of years. You agreed to sell that to the plaintiff for the sum of $10,000. She gave you a $5,000 deposit. We all agree that she gave you a $5,000 deposit. That's what she wants back. Now, are you back in the salon?
No, I'm not.
Well, are you not back in the salon because of COVID? You don't seem to indicate to me that you were not back to work in January.
I was back to work in January in the salon. And
January?
Yes.
Right. And you were back to work in February in the salon. You were back to work until they closed the salon. Possession of what you sold her until the state of Washington State, until they closed down all the salons.
I sold my assets to the building owner, which was Bill.
Just a second. So Bill bought your salon?
He bought everything that was inside the salon.
How much did Mr. pay you for the contents of the salon, other than forgiving you your rent?
It was the next 2 years' worth of lease. He let me out of that as well.
What do you mean as well? As well as what?
He let me out of the contract.
And?
And he forgave any payments.
And he took, just a second, and he took possession of all the furniture. Is that what you're telling me?
Yes, most of it. Mirrors, stations, roller carts.
So he took that because he knew he wasn't going to get any money from you.
No, he wanted to leave it there so that he could then, in turn, rent it out.
Well, that was a bad deal. I think I have a feeling that Bill got snookered. He got snookered by COVID, and he got snookered by you.
Not by me.
Why didn't you give her money back?
Because she told me
she gave you $5,000.
She wanted the salon. She didn't ask for it back. She also stated that I doubt you have it.
Just don't say anything.
She said, so I want everything that you have to do with this business.
Sure.
She wouldn't take her money back.
Just a second. You sold it to somebody. What are you?
I have her text message.
Judge Judy continues in a moment. Closed captioning sponsored by. Have you been cheated? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
You mean so you sold what she bought to somebody else and kept her money?
This was his idea. He came to me. I have a text message also that this was his, that he stated to me. This was his idea.
You hadn't paid rent to him then, by that time, for 5 months, and certainly weren't going to pay him for March, April, May, June, July, because all salons were closed in Washington State.
Right.
So he said, well, give me what you got. I mean, I can't get blood from a turnip, so I'm going to take over everything, and I'll let you out of your lease, and so I won't sue you for the back rent for 2 years, and goodbye and good luck. Is he a friend of yours?
The back rent was for 4 months. And
is he a friend of yours, is my question.
Not. I would say acquaintance, but not a friend. We don't have barbecues together.
He's an acquaintance. You have to give her back a deposit. Judgment for the plaintiff in the amount of $5,000. We're done. You see, you didn't have to say a word. Goodbye.
Pardons are excused.
Judge Judy continues in a moment. And on the next Judge Judy.
The horse's legs were bitten.
Yes. So can I interrupt?
No, you can't.
Next Judge Judy.
I'm thankful for